all those elementary schools are schools that are maintained by the district because it operates those schools. And the school board has the authority to decide who they're going to assign to each of those schools under New Hampshire law. If a district doesn't maintain a school, it is still obligated by law to educate the kids that are in the district up through the time those kids obtain a high school diploma or age 21, whichever is first. That's a basic obligation of New Hampshire law. All school districts have to educate all kids within the district until the kid reaches high school at the age 21, whichever is first. It's your obligation at district expense. That's what it says. That's in RSA 189-1A. So if you don't maintain a particular school, the district has to somehow educate those kids. And they're basically two choices. Maybe a few more, but I'm going to boil it down to two. The two main choices are that either the school district says, folks, you can go wherever you want. If you get into a school, we're going to, you can get into whatever school you want, and you can go to whatever school you want. And when you go to that school, the district's obligation will be to pay the state-determined tuition charge for that school. Good so far? So that's one choice. The other choice is that the district makes a contract with a school district or an approved public school. There are two private academies in the state that are public academies, excuse me, Co-Brown and Pinkerton, that also apply to this because they're grandfathered in this law. So, but you make an agreement with an approved public school to educate your students. If you make an agreement as a district with another school district, and that school district, and that agreement is approved by the State Department of Education, then for all intents and purposes of assignment, that school district is treated like a school that's operated by the sending district. So you can assign, so the school board has the ability to assign its students to that school. Is that better? A little better English?
It's better for me.
All right.
Okay, thank you.
So then on top of that, because you have a myriad of policies that intersect this area and that affect assignment. And those policies, there are two of them that are required by law. And one of them, which the school board has adopted. The two that are required by law are a manifest educational hardship policy. State statute mandates that all districts have a manifest educational hardship policy that allows parents to apply to the school board for reassignment to another school, either within the district or another public school outside of the district if there isn't another school, to transfer their students to another school if they're able to prove a manifest educational hardship. That is a policy that the district has, and I believe it's policy JEC. Is that correct? Yes, JEC. The State Department of Education has defined what a manifest educational hardship is. And that's in a state regulation and has defined the necessary level of proof that a parent must establish before the school board in order for the student to be reassigned. The Hooks at School policy, JEC, that deals with manifest educational hardship is a procedural statute that says if you apply, there's a certain amount of time that the school board has to process that decision. And once it's processed that decision, there are certain rights that parents have to appeal that up to the State Department of Education for determination of whether the school board made the correct determination that the parents did or did not approve a manifest educational hardship. That statute and that rule applies not only to high school students, it applies to all students in the district. It could apply to elementary school kids, it could apply to middle school kids. And all districts are required to have that policy. There is another policy, JCA, that is required by statute, which allows the superintendent to place a student based on a different standard, which is called the best interest of the student, the best interest of the child standard in a different school. This is an opportunity for superintendents to deal with students who otherwise cannot receive an education in their own school. And based on the determination of best interest of the child to reassign students. So those two policies are required by law. The only other thing I'm going to say is that the school district has adopted a third policy to deal specifically with high school students. The Hooksett School District has. It has adopted policy JCB, and in that policy it is determined that in order for high school students that are applying effective November 1 of 2008 to attend school in another district at the high school level, that the school district is going to apply the manifest, an educational hardship standard to make that determination. And that policy was adopted on November 1st by the school board after a series of public hearings, and is the current policy that's in place right now. It is my understanding that after initially adopting that policy, the board clarified sometime later that what it meant by educational hardship was manifest educational hardship as defined by ED 320, which is the state rule concerning allowing a child to attend another school based on a manifest educational hardship. And that's the current state of affairs in the Hooksett School District right now. Okay, so that's the background. Does that help? Maybe not, but
It does help. So just to clarify my understanding for the public, the first two statutes that you mentioned are required by law.
That's correct.
And the third statute, or the third policy you mentioned is not required by law but was adopted by the school board.
Correct, to deal with high school reassignment specifically.
Okay. All right. Okay. So thank you very much. Are there comments, questions for the board, for individual members of the board, for the district attorney, for the superintendent? Yes.
Go on.
I think that's good, just so that everybody can hear your question.
I got a slew of questions, but I'll just do one. It was mentioned that the citizens or taxpayers or citizens of the district were allowed to had to come before in a meeting, town meeting, in order to vote for the contract. I guess my question is, should changes in the policy that materially affect the taxpayer or individual party rights that are granted in a good faith negotiation of a contract be voted on in a public meeting as well? Since the contract is what established the right that was used as a basis of voting for 8 years worth of students. And what now we're dealing with is a policy change that's not required by law, but is been applied to create a new requirement, which is actually not in the contract. So the question would be is, do the citizens deserve procedural due process and to be able to vote on this at a public meeting? Thank you.
All right, and I'm just going to clarify here, okay? Because when you ask a question of the school district attorney,
Yep.
what he will give you is legal perspective.
Sure.
Okay? When you talk about deserve, things like that, those are not in the legal realm. Those are more in the policy school board realm.
I
So
can clarify if you'd like.
no, I'm very clear what you're asking.
Yeah.
I just want to be clear that the attorney will answer some questions based on a legal perspective, and the board may answer other questions based on the policy.
Since I got that out from
Yeah.
that perspective, because
Yeah.
I was kind of just working on this
Yep.
in situ here. I guess the question is, a contract that's brought before the people to be voted in, that gives specific rights that are granted in a good faith negotiation with another district, should citizens be given procedural due process to vote on it again if a material change is going to take place that affects that contract? That's my question.
Is that something you can answer from a legal perspective?
I don't, not briefly. I mean, it's not a shoulda, coulda, woulda. I mean, that ultimately the school board is the responsible party for making determinations concerning the policies that affect all students in Hooksett. And the contract is an agreement between the districts, Manchester and Hooksett, and the two are not the same. But within the operation of the Hooksett School District, the school board ultimately has the responsibility for developing all policies and making decisions concerning the placement of students in district schools. And that's clearly defined under statute, and the board has the authority to make determinations that, to make changes in policy and to determine the policies that are in the best interest of the district, and it's their fundamental responsibility under the law is to develop policies that are that provide for the education of students within the budget that the legislative body ultimately approves. And the legislative body, which is the school district meeting, is the body that's ultimately responsible for raising and appropriating the money to carry those policies that the board decides into effect. I hope that answers the question.
I have a question. I'm going to speak out loud. I don't need a mic. You need to still speak in your mics because we really can't hear you. But that's all right. Under JEC, Mr. Graham, you mentioned that the superintendent is authorized to make an assignment based on what's best interest. Does that mean best interest of the student who's currently attending that school, i.e. if they're currently attending Cawley Middle School, if something does not work well at Cawley, they could request assignment to another school based on best interest? And would that also apply to a student attending a high school, attending, not planning on attending? Can you clarify that? How does that in conflict with the school board making the decision under JCB?
How does it conflict with the JCB? So you want to, well, JEC is a unique statute. It was adopted in about, I'm gonna do this from memory, so don't hold me to this, in around 2004 or 5. I can look that up real quick. But when it was adopted, it has it doesn't create a right to an assignment to another school. It creates an option for superintendents to assign students to another school. And that's really important because, and the reason why I say that is because it says, notwithstanding all of the rights of people to appeal to the State Department of Education when they're in disagreement with the school district about, and the school board about decisions they've made, that in the instance of a reassignment based on best interest, there is no appeal of the superintendent's decision.